and wanting to hear about. So thank you for joining us. I'm going to turn it over to her. I do want to let you guys know if you have questions, you can put them into the chat. We're going to save time at the end for questions. So put them in the chat and we can make sure that we address them. If we don't have enough time, we're happy to also send the questions to her afterwards, and I will be happy to share the responses back at that as well. So go ahead and take it away.
All right, good afternoon, everyone. My name is Rachael Soule. I am the Director of Professional Regulations and Independent Practice at the American Psychological Association. I'm one of the lawyers who works in the Office of Professional Legal and Regulatory Affairs. I've been with APA for the last 4 years, and much of my portfolio has really been dedicated to analyzing how evolving state and federal laws impact the daily practice of licensed psychologists. So from scope of practice issues, access to care issues, to the regulation of specific treatment modalities like conversion therapy and gender affirming care. And I was actually part of the team at APA that worked on APA's amicus brief to the US Supreme Court in this very case that we're going to discuss today, which is Chiles v. Salazar. So to set the stage, this case centers on a highly debated topic of conversion therapy. But before we really dive in, I do want to make a quick note on terminology, and that is the fact that while the clinical and academic world have largely moved towards the more precise term of sexual orientation, gender identity change efforts, the legal system and the media, they still primarily use the term conversion therapy. And so for the sake of clarity and to align with language you'll see in the court documents, if you choose to read them, and the news headlines that you'll probably see, especially when the Supreme Court actually renders their decision this spring, I'll be using these terms interchangeably. So both sexual orientation, gender identity change efforts and conversion therapy, but leaning more towards conversion therapy for ease of reference. And one more quick aside, which some of you might know, but I am 36 weeks pregnant. So if I sound like I'm out of breath, it's because I probably am. So, pregnancy has a way of redistributing your lung capacity. So I may need to pause for a breather here or there. But on that note, I am so thrilled that we were able to squeeze this session in before two major deadlines, the Supreme Court ruling and my maternity leave. So that being said, let's dive in. So Chiles v. Salazar is a case, you might have seen it in the news, you might have seen it on listservs, but it's a case pending a decision currently at the US Supreme Court, testing whether Colorado's minor conversion therapy law, which is a 2019 law banning licensed counselors from providing conversion therapy on minors, and whether that violates the First Amendment's free speech clause. So Chiles v. Salazar is actually the first case involving a ban on conversion therapy that the US Supreme Court has agreed to hear. But there's been a plethora of other cases that have approached this topic, but it's never made it all the way up to the Supreme Court. So I'm going to dive in today on what's actually at issue in this case. We'll examine some of the arguments that were presented to the Supreme Court at oral arguments this fall, and what the potential outcomes could mean for psychologists, along with other regulated professionals pending the Supreme Court decision. So, because this is a really important case on an important topic that could have pretty far-reaching consequences, depending on how the court rules. So, I'm also going to use Chiles v. Salazar today briefly as a case study in judicial advocacy for APA to explain a bit more about how APA's amicus brief program works in practice and how psychological science can directly influence legal outcomes in situations like these. So that being said, the core question in this case is deceptively simple, and that is talk therapy professional conduct that states can regulate, or is it speech protected by the First Amendment? And I'm going to continue to come back to this question during this discussion because the answer does not just impact conversion therapy bans. It could affect every state's ability to enforce professional standards of care delivered through speech. So if the court rules that states cannot regulate what licensed professionals say to their patients or clients because it's just talking, We could be looking at a deregulation of professional advice across multiple disciplines. That's from psychology to medicine to accounting to law, any field where advice is the service. So that's what's really at stake here. And that's why, even though this case is about conversion therapy, it has implications that go much further beyond this one issue. So before we really dive into this case, I want to take a step back and look at the history of how we got here. Because the story of conversion therapy bans is, from my point of view, pretty interesting because this hasn't always been as highly political or polarizing as it currently is. And I want to start briefly by explaining what conversion therapy is for anyone who might not be super familiar. Also noting that I'm not a psychologist, but a lawyer, so many of you might even have a more robust background on conversion therapy than my understanding. But that being said, generally speaking, conversion therapy is defined as any practice that attempts to change an individual's sexual orientation or gender identity. The underlying assumption of these practices, for those who are not aware, is that being LGBTQ+ is some type of disorder that can be cured or needs to be fixed. And this stems back to when homosexuality was considered a mental illness. So historically, conversion therapy involved things like aversive techniques, shock therapy, shaming patients. But even as these methods around conversion therapy became less physical over time, the harm from these types of treatments was evident. And for decades, major mental health organizations, including the American Psychiatric Association, us, the American Psychological Association, and many more, scrutinized these treatments and have found that there's little to no evidence that these treatments actually work, and significant evidence to support the fact that these types of efforts do cause harm. And because of this evidence, we saw a wave of legislative action. It began in the 2010s with California becoming the first state to ban conversion therapy on minors by licensed professionals in 2012. By the mid-2010s, many bans were passed, many of which had significant bipartisan support. I like to use Connecticut as a really good example because in 2017, they passed their ban. It passed their Senate unanimously, 36-0, and then passed their House almost unanimously, 141-9. Many of the bans that we saw during the mid-2010s, they focused on issues like medical consensus and consumer protection. New Jersey is actually a really interesting example because that state supported conversion therapy explicitly as a form of consumer protection. So it argued that the conversion therapy providers were defrauding consumers. And there was actually a court ruling in New Jersey that found that describing homosexuality as a curable mental disorder violated the Consumer Fraud Act. This even inspired federal legislative efforts, including the Therapeutic Fraud Prevention Act, which was introduced into Congress in 2015. And that would have made conducting and or advertising conversion therapy an unfair trade practice that would have been enforceable on a national level by the FTC. Unfortunately, that bill did die in committee, but it has been reintroduced a number of times and actually was reintroduced recently. But it hasn't thus far advanced beyond committee. We even saw bans being passed in these deeply conservative states like Utah, which passed their ban in 2020. And I bring this history just to show how initially the issue and these conversion therapy laws were seen as common sense consumer protection measures grounded in scientific evidence. However, in the last couple of years, I want to say like 3 to 5 years, the issue has become increasingly polarized, with certain conservative states like Indiana actively blocking these protections and federal courts facing challenges of these bans on First Amendment grounds. So if you take a look at the map on your screen, you can see the deeply green states that are states that prohibit state licensed health providers from subjecting minors to conversion therapy. And then you see the 4 or 5 states in orange. So these states limit local level protections against conversion therapy in different ways. Some, like Indiana, outright prohibit local governments from enacting these bans. Others, like South Carolina, they use funding restrictions to deter local actions. And then in the 11th Circuit, which covers both or all three, Alabama, Georgia, and Florida, the federal court ruling in Otto v. City of Boca Raton, which we'll talk about a little bit later today, that effectively blocks enforcement of local bans altogether in that circuit. So then you see the 4 states in Puerto Rico that are striped in green. So these have some kind of conversion therapy protection. So they've taken some state level action to restrict conversion therapy on minors in different ways, but they stop short of an actual full ban. And so North Carolina is one of these states. And since we're here today, I thought it would be worthwhile looking at what that means for your state specifically. So North Carolina took what I'd call the middle ground approach that a few jurisdictions landed on in the late 2010s, showing clear executive concern that conversion therapy is harmful to minors based on clinical science, but the state never passed any type of comprehensive ban. So I pulled up the executive order that you'll see on the screen, but in 2019, the then governor signed this executive order. And essentially what it did is it directed the Department of Health and Human Services to prohibit the use of state and federal funds, including Medicaid and Health Choice, for conversion therapy performed on minors. So the executive order itself is worth noting, and I pulled up a lot of the language on the screen. Obviously, I couldn't fit the whole executive order, but it thoroughly lays out the case against the practice, and it cited the opposition of virtually every major medical and mental health organization in the country, including the American Psychological Association, the American Psychiatric Association, the American Medical Association, the American Academy of Pediatrics. So a robust level of support. And this executive order frames the issue not as a political debate, but as a matter of public health and consumer protection. So the thing to understand about this particular executive order is the legal mechanism it uses. So what it does is it cuts off public funding. So if you receive reimbursement through Medicaid or Health Choice, you can't bill for conversion therapy on minors. But the executive order itself is not law. That actually bans the practice outright. So if you're in private practice, for example, and don't rely on state funding, the executive order doesn't reach you. And because it is an executive action and not an actual statute or law, a future governor can rescind it without any type of legislative process. So right now, for practicing psychologists in North Carolina, the primary professional constraint on conversion therapy for you folks, it's not the state law, it's this executive order, which is based on billing and ethical guidelines, including APA's own ethical guidelines that opposes this practice. But on that note, there have been significant efforts to move in North Carolina to move towards a more comprehensive statewide ban through the legislature. Most recently, in the current legislative session, we saw the introduction of Senate Bill 382, the Mental Health Protection Act, and House Bill 645. So these bills aim to close the gap left by the executive order by actually codifying the ban into state law. So under SB 382, licensed mental health professionals, including psychologists, would be prohibited from engaging in conversion therapy with anyone under 18 or any adult with a disability. And critically, it would also classify conversion therapy practiced by a licensed professional as unprofessional conduct. So that is a pretty significant escalation from a funding restriction to an actual professional conduct standard with teeth. And so House Bill 645, that's an omnibus bill that is a bit broader, but it does include a conversion therapy ban with the same structure or similar structure as SB 382. Both bills are currently seem a bit stalled in this session, and they haven't moved out of committee. But I still wanted to highlight these North Carolina specific developments because they bring us right back to the central tension in Chiles v. Salazar. So the governor's executive order and these pending bills are built on the legal foundation that therapy is professional conduct, that the state can regulate to protect its citizens from harm. And so I want you to take a minute and think about that architecture. So the executive order is grounded in the state's role as a steward of public health funds. It says the state will not pay for a practice that medical experts have determined is ineffective or dangerous. Senate Bill 382 goes further. It classifies conversion therapy as unprofessional conduct, subject to licensing discipline. That is not a regulation of speech. This is the state exercising its traditional authority to set minimum standards of care for licensed professionals. And this is the exact legal question at the heart of Chiles v. Salazar. Is therapy professional conduct that the state can regulate, or is it speech that the First Amendment protects and therefore cannot be regulated? So this brings us back to Chiles v. Salazar, and I just want to talk about the parties really quick in this case. So you have the petitioner, Kaylee Chiles. She's a licensed professional counselor in Colorado, and she's represented by the Alliance Defending Freedom, which is a conservative Christian advocacy group. And you might actually recognize their name because this organization has been at the forefront of many recent landmark Supreme Court cases, including the Dobbs decision that overturned the right to abortion. So then you have the respondents in this case, and that is the state of Colorado, specifically Patty Salazar, who I believe she was the former, not the current, executive director of the Colorado Department of Regulatory Agencies, along with other state officials tasked specifically with enforcing professional standards. So let's talk for a minute about what Colorado's law actually says. So specifically, Colorado's law prohibits licensed mental health care providers from engaging in conversion therapy with patients under 18. It defines conversion therapy as any practice or treatment that aims at altering an individual's behavior, including efforts to change an individual's sexual orientation, efforts to change behaviors or gender expressions. But what this law does not do is it doesn't prohibit any type of facilitating, coping, understanding, support, and identity exploration. This is actually similar to language in the North Carolina Executive Order, which carves out practices that provide acceptance, support, or understanding, or practices that facilitate coping, as long as those practices don't specifically seek to change orientation or identity. So Colorado's law, very similar to certain provisions in North Carolina's executive order, very clearly includes a clause that allows therapists to help young people explore their sexual orientation or gender identity ethically. And this is an important distinction. By law, state licensed therapists are already allowed to help youth explore their identity. They cannot, however, pressure children toward a specific predetermined outcome. And what's interesting here, and I didn't bring this up during PSLC, but it's not even clear that the therapy that Ms. Chiles wants to perform even violates this statute. The plaintiff in Chiles, Ms. Chiles, she actually insists in her complaint that she does not want to change someone's behavior or identity or orientation, and that at most, she wants to talk about sexual orientation and gender identity, which she says might include counseling someone to cope with the sexual orientation or gender identity that is causing them stress. And this very well could fit into one of the exceptions that I mentioned already exist in Colorado's law. And in the pleadings, the state of Colorado actually argues this. So it's not really clear that what Ms. Chiles even wants to do is even prohibited under the statute, which would mean that the law wouldn't and couldn't be enforced against her, which would also mean that she doesn't have standing to challenge the law. And I won't go deep dive into that, but this is a procedural issue. It did come up during oral argument, but the Supreme Court seemed very eager to avoid that argument. But it's worth noting because it raises the question about whether this case should even be before the Supreme Court. Still, I really want to focus on just how narrow this law actually is. So the law only applies to licensed mental health providers and only when they are treating minors. So if the petitioner in this case, Ms. Chiles, even if her conduct did violate the statute, under Colorado law, she has several options if she feels the need to provide this type of prohibited practice. One, she can give up her license. She can open up a shop and provide conversion therapy to anyone who wants it. This law does not apply to religious ministers. It doesn't apply to life coaches. It doesn't apply to unlicensed counselors. And even more, and the state actually makes this very clear throughout this case, she can actually keep her license and still provide this type of counseling, provided she does so in a different capacity. So, for example, let's say she's the minister of a church and a licensed therapist. She can say to clients who want this type of therapy, look, I can't provide this therapy in my capacity as a licensed therapist, but I can do this in my capacity as a minister or as your spiritual counselor. And under Colorado law, that would be perfectly legal. So what Ms. Chiles cannot do under this law is she cannot get a license, which is a stamp of approval from the state that tells the public she is practicing according to modern evidence-based standards, and then provide a treatment that violates those very standards. In that sense, in creating this law, the state's position is very simple. They're essentially saying, listen, you can say whatever you want. You just can't say it while claiming our professional endorsement if what you're doing is harming our population. So I also want to note that the enforcement mechanism for this prohibition, so rather than creating a standalone prohibition, Colorado structured this as a professional licensing regulation. Engaging in conversion therapy with a minor constitutes unprofessional conduct, subject to disciplinary action by a relevant licensing board. So as we talk about this case, I want you to keep in mind just how narrow this restriction actually is. So Colorado's law, it's similar to more than 20 other state laws that very narrowly and specifically prohibit state licensed mental health professionals from attempting to change a minor's sexual orientation or gender identity unethically. It is a targeted protection for youth enforced only through the privilege of a professional license. Take a quick water break. So now I want to give you just a brief primer on First Amendment doctrine, because you will need this to really understand the legal arguments that were presented during oral arguments. So I think we all know that the First Amendment protects freedom of speech, but not all speech is protected equally. So when a specific law singles out and restricts a specific opinion being expressed, this is known as viewpoint-based restriction. And the legal system treats this as a major red flag. So these types of laws are considered presumptively unconstitutional, and the court applies to these laws its toughest test, which is known as strict scrutiny. So under this standard, the state government would face a massive uphill battle to prove to the Supreme Court that the law is absolutely necessary. On the other hand, regulations of professional conduct, these are regulations that only incidentally burden speech, and they have been traditionally subject to a much lower degree of scrutiny. This is known as rational basis review, which only asks whether the law is rationally related to a legitimate government interest. And almost all laws survive this rational basis review. So back to that key question in this case. Is Colorado's law regulating professional conduct, which would be subject to a lower scrutiny, rational basis, or is it regulating speech based on a particular viewpoint, which would be subject to a much higher degree of scrutiny, which would be strict scrutiny? So let's walk through how the case got to the Supreme Court and the role that APA played and their judicial advocacy. So in September of 2022, Ms. Chiles, she sued to block Colorado's law from being enforced, arguing it stopped her from providing this type of faith-based talk therapy to those who specifically sought that type of treatment. And the district court denied her request and essentially said they didn't think she was likely to win. What the court ended up finding is that Colorado's law is a legitimate regulation of a specific therapeutic practice, conversion therapy, that the evidence shows is harmful and ineffective for minors, and that this law protects professional conduct rather than restricting speech, and therefore should be upheld. Ms. Chiles then appealed to the 10th Circuit Court of Appeals, and this is where APA's judicial advocacy became directly impactful. So to defend Colorado's law, APA filed an amicus brief which is essentially a document that provides the court with expert information to help inform its decision. So our brief, it was firmly grounded in our 2009 task force report on appropriate therapeutic responses to sexual orientation. And the report was a comprehensive 124-page review of the scientific literature in this space. As you'll see on the screen, it looked at 87 peer-reviewed studies, and it was specifically a systematic analysis of empirical research on sexual orientation change effort treatment outcomes published over the course of half a century, so from 1960 to 2009. And the findings were clear. Sexual orientation change efforts were ineffective at changing sexual orientation, and even more critically, the research demonstrated that such efforts do cause significant harm. So here, the 10th Circuit didn't just read APA's brief discussing this report. The judges relied heavily on it to make their ruling, and I pulled text from the actual opinion from the 10th Circuit and highlighted some of the citations to APA's task force report and to APA's amicus brief. So the court cited APA's findings throughout its entire opinion in concluding that conversion therapy is harmful to minors and that the state has a legitimate interest in protecting children from this discredited practice. And the result was the 10th Circuit upheld the law, affirming that Colorado's law was a constitutional regulation of professional conduct, not a restriction on speech. And this perfectly illustrates the goal of judicial advocacy. It takes complex scientific data and turns it into the legal authority judges use to protect public health and make certain decisions. So the 10th Circuit isn't an outlier. Other appellate courts have similarly relied on APA's amicus briefs or our scientific expertise to uphold conversion therapy ban. And when I say APA and our, like, we have worked with a lot of SPTAs in this space. We've had SPTAs sign on to many of our amicus briefs, so it's not just our effort. I just want to make that clear. So we saw early victories in 2014 in the 9th Circuit and the 3rd Circuit with upholding California's conversion therapy ban and upholding New Jersey's conversion therapy ban. Both of these cases, the courts relied heavily on APA's task force report to rule that states have a legitimate urgent interest in protecting minors from harm. I'm going to skip over that 4th Circuit case because that case was decided on procedural grounds rather than the First Amendment merits. But I want to dive into the 9th Circuit case in Tingley v. Ferguson. So in 2023, APA filed an amicus brief in this case supporting Washington's conversion therapy ban. So the 9th Circuit did ultimately uphold Washington's conversion therapy law. And this case is particularly significant because the court had directly tackled the argument that is at the heart of Chiles. So the claim that talk therapy is speech and therefore immune from regulation. So the plaintiffs in Tingley made the exact same legal argument that Ms. Chiles is making now, that because their therapy consists only of conversations, not physical interventions, it's protected speech that the government cannot regulate. So the 9th Circuit rejected that argument outright. And the court said something very powerful in its ruling, and it said that the tradition of regulating medical treatments does not just end merely because those treatments are implemented through speech rather than a scalpel. So let that sink in for a minute. That one line captures the entire issue. Just because a professional treatment is delivered through words does not transform it from conduct that the states can regulate into speech that the First Amendment protects and therefore cannot be touched. If that were the rule, states couldn't regulate psychotherapy at all. They couldn't regulate medical advice. They couldn't enforce standards of care for any professional where the service is talking to people. So this framing from the 9th Circuit case is exactly what the Supreme Court needs to adopt in Chiles v. Salazar. If the Supreme Court adopts this framework, then states would retain their traditional authority to regulate professional conduct, even when that conduct happens through speech. So in each of these cases that you see on the screen, and some that I couldn't fit on this PowerPoint. The courts looked at the scientific consensus that APA helped establish to conclude that states have a legitimate authority to protect minors from these practices. But unfortunately, there were a couple of circuits recently that went the other way. So in 2020, the 11th Circuit, and if you remember those 3 orange states on the map. So in 2020, the 11th Circuit struck down Florida's conversion therapy ban in the case Otto v. City of Boca Raton. So in a direct departure from the other courts, the Otto majority concluded that speech-based therapy is not conduct at all, but pure speech is what they called it. And so by labeling therapy as pure speech, the court held that any regulation must face strict scrutiny, which again is that most demanding constitutional test that I mentioned earlier, making it extremely difficult for states to regulate professional conduct. And here's the problem with that logic. If talk therapy is pure speech immune from regulation, how do states enforce any professional standards? States routinely prohibit doctors from recommending harmful treatments or practicing below a standard of care. And all of those prohibitions work by regulating what doctors say to their patients. Under Otto's logic, every one of these types of regulations would face strict scrutiny and would have a high likelihood of failing. So the Otto decision created a circuit split where the 9th, 3rd, and 10th circuits had all upheld conversion therapy bans, but the 11th Circuit struck down the same type of law. So you have the same law, opposite results. And that's why the Supreme Court agreed to hear Chiles v. Salazar to resolve this conflict. And here's where the timing gets a little more interesting and a bit more controversial. So the Supreme Court decided to hear Chiles v. Salazar in the spring of 2025, so in March of 2025. But this past December, so recently, after the Supreme Court had already agreed to hear Chiles v. Salazar, and after they had already heard oral arguments in this case, the stakes were raised because the 6th Circuit decided a case called Catholic Charities v. Whitmer. And here, the 6th Circuit joined the 11th Circuit Otto decision in adopting this talk therapy is entirely speech and cannot be regulated framework, striking down Michigan's conversion therapy law. So in that case, we did file an amicus brief supporting Michigan's ban, but the court still ruled to overturn the ban. And like I said, the court adopted Otto's framework, wholesale calling talk therapy spoken words and nothing more. And the thing about the Whitmer decision is that it created significant controversy because of its timing and because of its direct conflict with the 10th Circuit's reasoning in Chiles v. Salazar. So it's generally unprecedented for a federal appellate court, so for a lower court, to decide an issue that the Supreme Court is actively considering. Not only did this decision create a deeper circuit split, but because of its timing, it's seen as like a ploy to potentially attempt to influence the Supreme Court's decision, which, you know, you're talking about like the boss and these lower courts saying like, we want you to be influenced by this. They don't want to hear it from them at that time when they're already in deliberations. So for that reason, the case did face a pretty dire dissent that argued that the 6th Circuit should have waited. Generally, all courts do wait for the Supreme Court to decide before weighing in. But they didn't wait. And now we have 2 circuits, the 11th and 6th, holding these bans unconstitutional versus 3 circuits, the 9th, 3rd, and 10th, upholding them. So, as I mentioned, the Supreme Court, they agreed to hear Chiles v. Salazar in spring of 2025. And we have to remember that the decision at the Supreme Court doesn't just affect Colorado or North Carolina. It sets a constitutional ceiling for professional regulation across the entire country. So luckily, APA's amicus program has a long and distinguished history at the Supreme Court, and many of our amicus briefs have been directly cited by the Supreme Court in their opinions. So when this case moved from the 10th Circuit to the Supreme Court, you know, we rallied and we wanted to submit another amicus brief, but now an amicus brief submitted at the Supreme Court, it needed to do more than our brief at the 10th Circuit. It needed to address the specific arguments that would be raised at this high level. It needed to anticipate the justices' concerns, and it needed to present the scientific consensus in a way that would withstand a more rigorous scrutiny. So because the petitioner in this case, Ms. Chiles, or the attorneys for Ms. Chiles, kept calling therapy just a conversation or pure speech, we added a brand new section to our Supreme Court brief that was different than our 10th Circuit brief. And the goal here was to flip the script, and we titled it Therapy is Evidence-Based Mental Health Treatment. So we explained to the justices that therapy isn't just talking. It's a clinical intervention performed by licensed experts who are governed by strict standards of care. We even pointed to research showing that therapy produces measurable outcomes in the brain, much like medication does. And by doing this, we were essentially telling the court this isn't about censoring speech. It's about regulating a medical professional's conduct to ensure it meets a scientific standard. And so for our Supreme Court brief, we also joined forces with the American Psychiatric Association, along with 12 other leading medical and mental health professional organizations, signaling a unified consensus to the court. And aside from the argument I just mentioned, just some other key takeaways I want to briefly mention. So one of the arguments we brought up is how sexual orientation, gender identity change efforts, they are not legitimate medical treatment. So this was foundational. So the petitioner frames conversion therapy as another form of counseling. So like a legitimate treatment option that the state is censoring. And our brief directly refutes that framing, saying, no, these are not legitimate. This is a discredited practice that fall outside the professional standard of care. And then the other important argument in our brief was how minors are particularly vulnerable. And this is where our brief addressed why state regulation of these practices is especially justified. We went into much more detail, but we discussed how minors are particularly susceptible to harm due to their developmental stages. And therefore, states have a particular interest in protecting this vulnerable population. So let me take a brief minute to talk about the evidence, because this is where the legal and scientific worlds often collide. So if you remember that constitutional framework I explained earlier, when a state defends a law, it must justify that law with some type of evidence to prove the government has an interest in restricting that type of speech. So the professional consensus and the research record that are provided in things like amicus briefs are central to demonstrating a compelling or at least a legitimate state interest, depending on the standard of review, to support that regulation. So let's get into the oral arguments. So the oral arguments were heard on October 7th of 2025, and they centered on the tension between free speech protections for counselors and clients versus state regulatory authority over licensed healthcare professionals. And this brings us back to that fundamental question. Is therapy a protected conversation, or is it regulated medical procedure or professional conduct? So the Alliance Defending Freedom, which again are the attorneys for the petitioner, Ms. Chiles, they didn't just argue for their client, they argued to set a precedent. And their strategy rested on two pillars. They argued that because their therapy consists of entirely words, no medical procedures, no physical interventions, any ban is a gag order on speech. And they claim that this law in particular is viewpoint discriminatory. And this was actually their most effective point. They pointed out that one therapeutic goal, affirmation, is permitted, while the opposite goal, change, is banned, even if both are delivered through talk therapy. So the ADF argued that this was the government picking sides based on their views. And this argument, the state government picking sides. And this argument got significant traction. And even Justice Kagan, who is considered one of the court's more liberal justices, seemed really troubled by it. So I want to play this quick clip that kind of breaks down her questioning.
This is a big assumption on your part, but just assume that we're in normal free speech land rather than in this kind of doctor land. And if a doctor says, I know you identify as gay, and I'm going to help you accept that, and another doctor says, I know you identify as gay, and I'm going to help you to change that, and one of those is permissible and the other is not, that seems like viewpoint discrimination in the way we would normally understand viewpoint discrimination.
I don't disagree with that, Justice Kagan, and that's why medical treatment has to be treated differently. Because anytime you exclude one harmful practice, you are by definition saying these things are allowed because they are not harmful, and these things are excluded because they are harmful. That's the driving force behind regulating the particular practice.
So that second voice that you heard was the attorney for the state of Colorado. And what she's essentially saying there is she's saying, like, this isn't about anybody's particular view. This is about one treatment causing harm and another treatment not causing harm. And that's why we should be able to regulate, because it is conduct. So Colorado, backed by APA's research, they countered, this is not speech, this is conduct. The therapy provided by a licensed professional is a form of medical treatment subject to a standard of care and a fiduciary duty to a patient. They asserted that talk therapy is similar to surgery, that the state has a longstanding right to ban treatments that are proven to be substandard or dangerous. And several justices actually threw out examples with hypotheticals testing that theory. For example, Justice Sotomayor, she asked whether a state could prohibit a dietitian from encouraging anorexic patients to engage in restrictive eating. Justice Kagan gave an example of a doctor telling a patient to lower their cholesterol by going out and eating dessert for every meal. The implication being, if applying strict scrutiny would prevent states from banning this obviously harmful advice, then strict scrutiny is the wrong standard to be applying. Professionals cannot have unfettered power to say whatever they want to vulnerable patients, especially when that advice is demonstrably dangerous. So a particularly strong point that Colorado made, which from my point of view was more like a warning to the justices, was that if talk therapy is speech, when it comes to a standard of care regulation, you cannot subject such regulations to strict scrutiny, because if you do, then you have the courts, not medical professionals, not licensing boards, and not scientific organizations that will be the ones deciding what the medical standard of care should be. And this argument did get some traction too. We had Justice Barrett, who is one of the more conservative judges, and he asked some very pointed questions, for example, about how medical malpractice law could function if talk therapy were fully protected. So overall, the questions from the justices revealed a court that was deeply divided and skeptical of both sides. Several conservative justices, like Justice Alito, expressed concern that if the court labels all therapy as conduct, it would give the government unfettered power to censor any conversation a doctor has with a patient, even on topics like abortion or religion. The liberal justices, like Justice Sotomayor, pushed back, pointing to APA's research. They questioned how a practice that science proves is harmful to children could be protected just because it's done through talking. So where does that leave us? Let's see. So we're expecting a decision by the end of the term, which is likely to be June 2026. But in reality, the Supreme Court could issue a decision anytime between now and June. But because this is a complex and controversial topic, we're really expecting it at the very end of the term. But whatever the court decides, again, will be binding precedent across the entire country. And there are essentially 4 ways that the justices might go in their ruling. So the first would be the court could uphold Colorado's law. And this would be a win for regulation. And this would affirm that states have the right to protect patients based on scientific evidence. And this would keep the 23 current state bans safe, 23 plus current state bans. On the flip side, the court could rule that Colorado's law is unconstitutional. And this could spark a domino effect where bans across the entire country are suddenly vulnerable to constitutional challenges. If they decide that therapy is just pure speech, it could make it much harder for states to regulate any professional advice, whether it's in a therapist's office or a doctor's exam room. The third option is a bit more nuanced. So the court could strike down Colorado's specific law without killing conversion therapy bans entirely. So they might say this particular law was worded too broadly or had procedural flaws. For example, finding it unconstitutional as applied to Mrs. Chiles' specific practice while leaving the statute intact for others. And this would let other states keep their bans as long as, or other states could enact their own bans, as long as those specific bans were tailored to fit whatever the court's new parameters might be in this ruling. And then the fourth way that the justices could rule is they could remand the case. So this basically means, and this was floated during oral arguments, so this basically means that they could send it back to the lower courts. And this usually happens when the Supreme Court wants the 10th Circuit to take a second look using a different legal standard. So in this situation, the 10th Circuit and the district court, they use rational basis review to say this law is constitutional. And the Supreme Court could say, you know what, 10th Circuit, look at this case again, but I want you to apply strict scrutiny. So we kind of see this as a stall tactic. It would give us more time because it wouldn't be a concrete ruling. But it's usually a stall tactic for a court that's really troubled by the arguments of both sides, but isn't really quite ready to issue a sweeping national ruling, for example. So based on the oral arguments, there is a high likelihood that this ruling will not go our way. A majority of the justices did appear, even Justice Kagan, like I gave you that example, did appear pretty skeptical of Colorado's ban and the speech implications. So we could be looking at a majority or even a possible supermajority to strike down this law. But I want to bring this back to what that means for you as licensed psychologists in North Carolina. So if the court rules that talk therapy is protected speech subject to strict scrutiny, it doesn't just affect, again, any type of conversion therapy ban or the executive order. It calls into question the entire framework for your licensing board, or that your licensing board uses to hold you to a standard of care. So think about what your board does every day. It sets boundaries on what licensed professionals can and cannot do in a treatment setting. Many of these boundaries regulate what you say to your patients. If the court decides that states need to clear the highest constitutional bar every time they regulate a treatment delivered through conversation, your board's ability to enforce professional standards gets significantly harder. And that affects malpractice, that affects disciplinary proceedings, that affects the very thing that separates you as a licensed professional from an unlicensed life coach, for example. So here in North Carolina, where there is no statutory ban on conversion therapy and the executive order can be rescinded at any time, the regulatory framework protecting this vulnerable population is already pretty thin, and a ruling that weakens state authority to regulate professional conduct makes it even thinner. So still, despite this ruling, whatever it should be, this shouldn't turn us away from judicial advocacy. In fact, it makes our presence in the courts more vital now than ever. We have to remember that judicial advocacy is a long game, and our job is to put the scientific evidence in front of the courts. So even when a court disagrees with us today, we are building the record for tomorrow. And I showed you that example of how much the 10th Circuit leaned on APA's research, and that evidence doesn't just disappear. The scientific record, it becomes part of the legislative history, part of the judicial record that future courts, future legislators, and future advocates will continue to draw on. So if the court does rule against us, we pivot, we look for ways to distinguish future cases, and we advocate for legislative tweaks, and we continue to educate the public. Science doesn't change because legal standards does, and our commitment to protecting vulnerable populations remains the same, and APA will continue to show up in court to make sure that this evidence is heard. So that being said, I went a little longer than I was hoping, but we should have about 10 minutes left for questions. So I'm going to go ahead and stop sharing my screen.
And I see one that has popped in. What is the best way to keep track of when the court announces its decision?
Well, APA is definitely tracking this. I've been writing articles. I wrote an article about the Whitmer decision. So APA is definitely a good resource. If you get our practice updates, it will be in there. But I can guarantee that when the Supreme Court renders a decision, you're going to see it everywhere. You're going to see it all over the news. There was a lot of mainstream media when oral arguments came out talking about this issue. So I doubt you'll miss it, is what I'm saying.
Does anyone have another question? I didn't see any. Oh, let's see. Question. My read on how the court has been operating is to pretend that the Establishment Clause ban has been changed by pretending some cases are violating free exercise clause. The way this case is framed makes that analysis push toward the third or fourth holdings. Do you agree? And that's in the chat as well.
Um, so the way I see the court ruling is, and I have been wrong because the Supreme Court has made some, it just feels illogical for me for the Supreme Court to have like such a bold-faced ruling that would impact so many professional regulations. But a lot of analysts are saying that that is what we're going to see. But the way that I see makes the most sense, especially on the questioning, is that there is going to be more of that third narrow ruling that isn't a broad sweeping ruling, because I think there's too many implications on how that would impact professional speech. But we've seen a lot of Supreme Court rulings recently that I'm like, that doesn't make sense. So it's really hard to say where the Supreme Court is going. A lot of, like I said, legal analysts are thinking that this is going to be like a broad sweeping ruling. So it's going to be interesting, and it's really hard to say.
Any other questions? Does anyone have a question they want to type into the chat, or they would just like to unmute and ask? You're welcome to do that as well.
Well, oh, go ahead, Brian.
Yeah, it seemed to me that any argument would have to focus on the harm of the speech, the harm of the conduct, whether it was speech or with the scalpel. That I think anyone would agree that if I advised a patient that they should commit suicide, I'm telling this in words and it's speech, but all would agree that would be a wrong practice, and that the argument must emphasize that the research shows that conversion therapy leads to harm.
Yeah. So that is what the state of Colorado did argue. They're trying to say that these clearly harmful advice, whether given by a medical professional or a licensed therapist, should be regulated, and to take that away would be seemingly outlandish. But some argued that, but then you're giving the state power to tell the therapist what they can and cannot say in their.
But aren't they doing that again? If I can't tell someone that they should commit suicide, yes, your life is crap and you should do this. We are telling therapists that there are certain things you should not say, you should not advocate in any way, shape, or form because it's committing a harm. And I think that standard is an appropriate standard.
Yeah, and so the standard of care doesn't really change with this ruling. But the arguments there is that it becomes harder for a licensing board to enforce that standard, because if say there's a malpractice suit and a licensed therapist is saying, like, they're arguing, well, even though this is against the standard of care, you're violating my First Amendment rights to free speech, and I'm allowed to say whatever I want. And they can use now this Supreme Court precedent to make that argument.
It just seems like in a general conversation, you have freedom of speech. When you're acting as a professional, there should be regulations because your job is We don't take the Hippocratic Oath, but it still applies. Our job is to first do no harm.
Yes, agreed. And again, it doesn't change the standard of care. It just makes it harder for licensing boards if it was challenged to enforce that standard of care if it was challenged, if that makes sense.
Thank you.
Here, I was talking to myself. Do you think this has implications for psychological testing?
I think psychological testing would be a bit more protected because there is like a area of the law that I didn't go into much detail where it's incident to medical practice. So I do think that, you know, psychological testing might be a little bit more protected in that regard, if that makes sense.
Another one, did the arguments include the danger to licensure for attorneys?
They didn't go into that, but that is the full implication. Like it did stay in the medical realm, so they use medical doctors as an example. Most of the times, like most of the justices, they didn't really speak about attorneys, but you know, attorneys would very much that example would very well fit into this hypothetical because I mean, think about perjury, you know, anything. So
If there is a broad ruling that could lead to deregulation, is the APA preemptively taking any steps to protect our field and the view of us as professionals, as opposed to being degraded for being just talkers?
yes, we definitely are. We have been working very much on kind of workarounds and how, and I won't get into too much detail. Every state is a little different, but how um, states can, and we're gonna like roll some resources out on how states can work around this to make sure that the licensing is protected and that our profession is protected. But we are definitely aware of this, obviously, and working on that.
Okay, I'm going to put a pause right here. We are almost out of time. Wanted to thank Rachel so for all of her time.